Good afternoon, everyone. Welcome back to another episode of The Debt Life with me, Chad Van Horn. Today's topic is unemployed, underpaid, and overwhelmed. Unpacking your best options. Now, we're certainly still in a crazy time. Obviously, 2021, and this is our first one that we're doing this year in 2021, and changes have been made. Hopefully, things are getting better, but I'm seeing that there still is a lot of creditor harassment out there, a lot of stress going on in the world. So I certainly want to go through all of that. First, shout out to my tech team for organizing all of this and getting my light set up and my new camera, high definition camera worked out. So the worst thing you can do when you have creditors out there is just completely avoid them. I know it's a natural reaction to just put your head in the sand. I call it the ostrich approach. Hopefully nothing will come of it. I just met with a client this morning who took that approach on a deficiency judgment on a vehicle. Basically turned in a vehicle about 10 years ago. The deficiency was about $15,000, and he just let it sit out there. Deficiency judgments are good for 20 years. You can renew them for 10 more years in Florida. And unfortunately, what happened this morning is that judgment came and they took his current vehicle that was paid off worth about $25,000. So now what they're going to do is they're going to sell that vehicle and pay off this judgment in full. And it was actually his work vehicle. It was a limousine that he uses for work. So he's in a really bad spot. We're going to try to negotiate. We're going to try to work something out. It's very difficult to negotiate whenever they're holding all the cards at this point and they have an asset where they could just sell and get paid. So my number one piece of advice is don't ignore the creditors. Don't just let them sit out there. Try to take it head on. You might have to bite the bullet, whether it's going through bankruptcy, negotiating, or whatnot. But those judgments are just going to sit out there forever, and eventually they're going to come back to bite you. So let's go through some of the options that you have with your creditors. As I said, if you reach out to them, a lot of these creditors are willing to settle. And the best time to settle is prior to any of the wage garnishment, where they take your vehicle, where they take your assets, where they freeze your bank accounts. Because once they go through that process, they're going to wait to see what's in the bank account or what assets that they can get before negotiating with you. But if you reach out to them, many creditors are willing to work out payment plans. They're willing to take a reduced amount, maybe reduced interest and fees. And if you have a lump sum, they're willing to take a significantly reduced amount, because there's always a threat of bankruptcy out there for these creditors that they have to weigh into their calculation of what they would do to settle. So that's mostly with credit cards, deficiencies, any other lawsuits that could be filed that become judgments. You can reach out to the creditors at any time. If they do have attorneys or if they do have collection companies, generally speaking, the creditors are going to require you to speak to those collection companies or the attorney that handles the judgment and has the judgment entered against you. So if you had a credit card with Discover and they passed it down the road or sold it, you can't call Discover and settle with them at that point. Another very common debt that's in collection right now that we're seeing is medical debt. Medical debt, the good part about medical debt is it rarely reports on your credit, so it's not going to negatively impact your credit. And we've seen them take significant discounts, especially if you can prove financial hardship. So how do you prove financial hardship? Basically, you can put together a personal financial statement, reach out to the doctor's office or hospital and work with them to work out a payment plan. I've seen payment plans as little as $5 per month with a significant discount. So once again, do not just ignore it. Don't wait for a lawsuit. Try to get involved earlier. The earlier you can get it settled. Generally speaking, we try to get it settled within 4 to 6 months of default. So when you stop making payments. Also, avoid scams. There's a lot of scams out there. Unfortunately, a lot of our personal information is on the internet, so people will have some accurate information. Make sure you know exactly who you're paying and why you're paying them, because once you get into these different scams, it's hard to get out of. Another thing that our clients are struggling with right now, just tons of mail, tons of letters, collection letters, attorney advertisements, and even where they're sending you a copy of a lawsuit. Some attorneys will mail you a copy of a lawsuit that's been filed. When the attorney notices come, it's kind of like when you get a speeding ticket. There's a public record out there. And attorneys know when lawsuits are filed, and some attorneys will monitor that and mail you a letter saying, hey, you need some representation on this. Why don't you reach out to me? Obviously, don't just hire an attorney from an advertisement. Look them up, see if anybody that you know has worked with them prior to moving forward, and make sure that this is the type of work that they can do to help you, and obviously understand what their fee setup is going to be as well. It is usually better to work with an attorney than some of these other companies out there that will advertise that they can settle your debts for you. And surprisingly, the attorney's fees are, generally speaking, less than what some of these consolidation companies charge. So it's good to know all your options. So what I would do is I'd recommend finding 2 or 3 attorneys that you'd want to talk to, and then reaching to those guys. So thank you guys for commenting. I'm going to answer some questions as we go through the show. Marcus, are the debt consolidations versus Chapter 13? What's a better option? So Chapter 13 and debt consolidation are very similar in one way, that you have one payment that you make monthly, and that payment is supposed to take care of your debts. So with the debt consolidation company, what you're going to do with them is they're going to say, we can handle this $20,000 worth of debts that you have between these 4 creditors. Our goal is going to be to work out a payment plan of approximately 4 years where you're going to pay $400 a month. So you end up paying, let's say, 80% of it. And their fee is built into that, which is generally speaking around 20 to 25%. So you're going to end up paying them $4,000 to $5,000 potentially through that payment plan. And their goal is, while they work through this, while you're making that monthly payment plan to them, they're going to be negotiating with your creditors to work out a payment that's acceptable. The good part about that is it keeps you out of bankruptcy. So it's going to keep a bankruptcy off your record. It's still going to negatively impact your credit because you're not making payments during this, so you're in default. And it's not guaranteed that, like a Chapter 13, which I'll get into. Some creditors will say, I don't want to settle. I want my full amount. I'm going to file a lawsuit, get a judgment, let the judgment sit out there, and then try to collect by garnishing wages. So in a Chapter 13, it's different in that you're making one payment, but it's more of a science based on your income and your assets, income, expenses, and assets. In a Chapter 13, you have to pay 90% of your disposable income to your creditors. There's something called a means test that we go through, Schedule I and J, and you have to pay the creditors at least what they would get if you filed a Chapter 7 liquidation. So if you had assets of, it's the same thing, if you had debts of $20,000, if you had non-exempt assets of $5,000, let's say you had $5,000 in the bank, you have to pay at least $5,000 over a 36 to 60 month period, depending on your income, if you're above or below median income. So with a Chapter 13, it's more of a guarantee that as long as you make your payments. With the credit consolidation, you're more negotiating and hoping that it's going to work out. The Chapter 13, your credit starts to rebuild right after you file the bankruptcy, so all the negative reporting is going to stop. The negative reporting doesn't stop with the consolidation until you settle all of the accounts. So that was a great question. Thanks, Marcus, for asking that. I'm going to go through a couple more things, and I'll get to some more questions. So going back to the collection notices, what I'm seeing are a lot of different aggressive credit letters and notices. I've even seen some where you're going to go to jail. I can tell you, debtor's prison has been abolished for 200 years. You're not going to go to jail for a civil debt. If you're getting these letters, and if there's letters in there that seem illegal, if they're making different threats, feel free to bring those to a consumer attorney like us, and we'll review them to see if there's some violations of the FDCPA or some other act. Actually, next I'm going to get into the FDCPA and what that is, but I want to answer a couple more questions. So, Miss Lexi, what type of creditors can take my tax refund? That's a great question. So the tax refund, thanks, George. I appreciate you joining. Let me know if I miss anything. So Lexi, what type of creditors can take your tax refund? Generally speaking, the only creditors that can offset your tax refund are government creditors. So if your federal student loans are in default, if you owe the IRS, if you owe basically the federal government money, those are the ones that can take your tax refund. Once the tax refund is put into your bank account, any creditor that has a judgment or a right to an offset can take that money, so it's not exempt. So you got to be very careful. Another thing that clients forget, if you have a credit card with Bank of America that's in default and your bank account is with Bank of America, they have a right to what's called offset that amount, meaning they can just take the money out of your account and apply it to your credit card. So that's in the agreement. So be very, 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 very careful with that. Let's do one more question and then we'll move on. Christina, how can I make sure I'm including all my medical debt? That's a great question. That's important for bankruptcy purposes as well. What we try to do and what we do to get all the medical debt, since it's not on the credit report, is we'll list all the places that you visited. As long as you get the original creditor, it will follow through all the debt collectors that follow behind it, because sometimes it'll go to 3, 4, 5 different companies before we file the bankruptcy. So as long as you get somewhere in that chain and you provide notice, generally speaking, it will be included. If it's not included, it's not the end of the world. There are ways to fix that later, but obviously it's better to just get your fresh start and get a discharge. If you're trying to negotiate with the creditors, it would be the same way. Reach out to who originally would have been the creditor, the doctor, the hospital, or whatnot, and they should be able to track down your account and who has your account. All right, so moving on, I'm seeing some questions about Biden and student loan forgiveness. I'll certainly get to that as well. Nothing has been passed yet, but there's been some things floated out there. So let's go to the FDCPA, which is the Fair Debt Collections Practices Act. There's also a Florida consumer equivalent called the FCCPA, which is basically the exact same, but it applies to original creditors as well. The FDCPA only applies to debt collectors, so an original creditor would not be a debt collector by definition. Under Florida, the original creditor is. For example, if you owe American Express money and they're collecting on it, they cannot violate the Fair Debt Collection Practices Act because they are the original creditor. But they still could violate the FCCPA, the Florida Consumer Collections Practices Act. So what the FDCPA was set up for is basically to protect consumers against collection practices that are against the law, that are deceptive, that sometimes are very, very effective, but they're effective for a reason that is not good. We have clients that have creditors that are calling their neighbors, that are calling their parents, that are calling family members, saying, hey, you need to lend your son, your daughter some money because they need to pay us. Are you going to let them go through this? Which obviously is embarrassing. And calling employers. So not very ethical tactics, but effective tactics. I have a client that we just represented who surrendered a property years and years ago in a bankruptcy and has rebuilt his credit. He's doing fantastically well. And they keep trying to collect from him, sending him letters on the debt and reporting it on his credit. So this is the third time that we've sued this company. And every time that we do it, the judge is more prone to award more damages because it seems like the creditor is just not learning their lesson. We think that these banks are very organized, or I used to think that these banks are very organized. And over the years, I've come to realize that that's just not the case. So just be careful out there. Make sure you're monitoring it. The 7 most common FDCPA violations are continuing to collect a debt that's just not owed. So if you settled it or if it was discharged, you don't owe the debt anymore. So if they're asking you for money, that's a violation. Illegal or unethical communication tactics. So if they're threatening you with jail time, if they're making any types of threats really towards family or anything like that, that's obviously going to violate it. Failure to verify the debt. So if you're trying to verify and figure out who you owe the money to, they're actually required to do that. Threatening illegal actions past the statute of limitations or when they can collect. So that's a tricky one because they technically can still file a lawsuit after the statute of limitations is run. The statute of limitations is a defense that you can bring up and potentially make it go away. Generally speaking, it's a 5-year statute of limitations in Florida. The creditor will falsely represent themselves sometimes, where they'll say they're an officer of the court. They'll provide case numbers and information, basically anything to scare you into giving them their debit card. And as I spoke about earlier, improper third-party contacts and excessive phone calls are regular, where they use these auto dialers to just call as many people as they can. So So there's some of the common FDCPA violations. If you find yourself being harassed like this, the best thing you can do is really just log everything, keep track of all the calls that you receive, what they say. Obviously, if you can verify the debt, if you can send them a debt verification letter, you can do that as well. But the more that you track, the better. Do not record the calls. I do have clients that come in and they have recorded debt collectors, which the debt collectors actually have software that mutes their voice somehow on a recording anyway. But it is illegal to record somebody in the state of Florida without getting their consent. So if you can get their consent, which they're not going to give you, you can record them. That's why when they're talking to you, they always say we're on a recorded line. And then if you continue on, then that's deemed giving your consent. So just try. I know it's frustrating, and I know you want to get these guys, but don't resort to the same tactics that they might be using against you. If you do feel like you have FDCPA violations, you certainly can reach out to us. There are consumer attorneys that handle FDCPA violations. You will see some big cases out there. Generally speaking, these aren't home run cases. It's $1,000 statutory violation. They can also be used to try to negotiate. So if you actually owed the debt, they violated the FDCPA. The creditor violated the FDCPA. We can try to negotiate down the debt and settle the FDCPA and the claim against you at the same time. The good part about the FDCPA, there are statutory attorney's fees. So if you have a good case, generally speaking, you'll be able to find an attorney that will take it on a contingency fee basis. There's a ton of FDCPA stories that I could put out there, but I see a bunch of questions coming out. I appreciate my team answering those questions on here as well. Let's take another one. Kimberly, let's take a look here. All right, this is a long one. My creditor list was not complete for my Chapter 13 last year, and I have my originals on hand. What's the fastest way to settle and move on? So what I would do is I would reach out to the creditors and provide them with your bankruptcy information, and try to negotiate with them directly, or give them notice where they would put a claim in the plan actually. So it depends where you are in the Chapter 13. If the Chapter 13 has already been discharged, you're done, then I would reach out to them, give them that Chapter 13 notice, see if they would go away, so give them the discharge notice. And if they don't go away, then look at negotiating instead of reopening your case and doing all of that. If you're in an active Chapter 13, I would amend the schedules, provide them notice, and have them file a claim in your 13. That way they would share in the distribution and eventually be discharged. Let's see, Brian here. Has Biden done anything to address student loan forgiveness or any kind of relief for any kind of debt? What I keep hearing is the $10,000 forgiveness. I have to imagine that that's going to be what passes first. It's going to be $10,000 worth of federal student loans, and there's probably going to be an income threshold for that based on your tax return. So if you make over a certain amount, you're probably not going to be able to apply for that. It probably is a good way to start. A lot of the debts, especially around the $10,000 mark, and if you're below a certain income, would be in an income-based repayment program anyway, where the debtor is going to pay zero and eventually qualify for loan forgiveness. So if they're in default and it's negatively impacting their credit and they're not going to pay anyway, it might be better to not use the resources to pay Navi and pay collectors to try to collect on this debt. Obviously, President Biden has much more information than I do, is privy to much more information than I do. I'm sure that there's plenty of reports that are coming out for him to review. I appreciate everybody asking these questions too. These are all great questions. Brian, is it okay to block the numbers of debt collectors? Absolutely. The problem is though with these auto dialers, they just keep spoofing numbers or changing numbers or anything like that. So let me put that on the screen as well. You absolutely can block the numbers. According to the FDCPA, if you tell them I don't have the money, stop calling me, and they continue to call, that is a violation of the FDCPA as well. We have many clients that will hire us basically to give them advice, and once you hire an attorney for dealing with this debt, you can give them our number, and they're not allowed to call you because they cannot call a represented party directly. They have to go through us, which their tactics don't work with us because we understand their tactics, and certainly they're not going to bully us into doing anything. And that's really what a lot of the debt collectors try to do. They try to bully you. They try to get you emotional. It's my experience that 90-something% of my clients want to pay the debt. They just can't. Especially now where the pandemic has hit and so many people have lost their job, lost their income, or losing their vehicles, losing just everything that they've built up. They want to pay, it's just they don't have the money. And I'm seeing it because I'm seeing a ton of evictions that are going to come through once the moratorium runs. And, it's really a scary time. Stephen, thank you. I think you're awesome too. We'll throw that on the screen. um, let's see here. Brian, again, do I expect bankruptcy reform in the near future? If so, would be best wait to consider filing bankruptcy? I do think that there will be reform. What the reform is going to look at, we're not sure. We saw something come through where they were talking about making student loans dischargeable, creating a new Chapter 10 bankruptcy with two options, which it's kind of like Chapter 7 and 13 anyway. So I'm not sure why you'd make the Chapter 10. Coming up with ways to make bankruptcy more affordable for clients. We're working on pre-post retainers where you don't have to come up with all the money up front. You can come up with a little money to get filed, and then do a payment plan. If you do have student loan debt and you're looking at discharging the student loan debt, I am recommending that you wait if it's just the student loan debt. If you have credit card, medical, other debts that's dischargeable anyway, I'd recommend filing the bankruptcy, getting it over with, so that you can rebuild your credit, because it's going to take about 12 to 18 months to rebuild. And we help with that as well for all of our clients that file with us. So the short answer would be I think that there will be reform. I don't know how helpful the reform will be or when it will happen, but hopefully it comes through soon and it helps a lot of people. All right, and let's see here. We're going to go back into it. I appreciate we have a ton of questions. I'm sorry, it's probably not going to be able to get into all the questions, but we're going to do our best. So moving forward, navigating joblessness, income reduction. We're obviously seeing a ton of layoffs. A ton of people are asked to take pay cuts. I've said this in the past. Always come up with a budget, a real budget. So as soon as you get that pay cut, if you know, okay, my paycheck's going to be $500 less a month, you need to do a budget based on that. So prioritize your debt. FPL, you got to keep the lights on, got to pay the water, got to pay your rent, got to pay your vehicles. And then when you run out of money, you have two options. You either stop paying, so the bottom of the list obviously would be unsecured creditors, or you find a side hustle. You work for Uber, you're delivering food, whatever you have to do, especially if your list, you're hitting the FPL and food, and then you can't pay your rent. Then you got to find that side hustle, find a way to make up the money that you're losing from that. Look for another job, whatever it might be. So always stick to that budget. Look at your bank statements to really see what you're spending money on, because if you don't do that, you're estimating, and my clients and me, I'm always off unless I look at the bank statements. So make sure you actually look at the bank statements. And finally, Brian, let me see here. Filing bankruptcy, what are the upfront fees to file you need on hand? The court's filing fee is $338. There's some other costs that are approximately $250 as far as credit counseling and other costs. So generally speaking, you can get filed for that. Then attorney's fees are anywhere from $1,000 to $2,000 on average, depending on how difficult your case is. And as I said, we work on payment plans, and there's firms that will do payment plans for that, because we know that times are tough out there, man. Somebody emailed me earlier, when's it a good time to reach out for help? As soon as you're struggling, as soon as your budget's tight and you don't think you'll be able to make payments to unsecureds, reach out immediately and help and have somebody put a plan together. Our consultations are always free. I meet with every client. And the best compliment I get after the consultation is, I feel so much better now. I'm going to be able to sleep. Because there are people that legitimately think they're going to jail. They're going to have to deal with this for the rest of their lives, and that's certainly not it. Don't let an issue like debt have a negative impact on your health which is and will be with you for life. So if you start feeling all of that stress, give us a call. We'll come up with a plan one way or the other to make sure that the debt is taken care of. We are here nights, we're here weekends, we're here whenever you're off work. We're going to be available sometime. We do video, we do phone consultations. If you want to come to the office, we're following all the COVID protocols as well as far as masks and everything. So feel free to call us at any time or make an appointment. We also have a couple books out there. The Second Life, the second book, The Debt Life, is real stories about people that have gone through different debt issues and how they were addressed. And we also have another one that basically the how-to guide for bankruptcy in Florida that I wrote a couple years ago. So let's see if there's I'm going to answer one or two more questions. Marcus, thanks for the shout out for Martha and Frank. They're really doing a good job, which is awesome. Cindy, thank you. If there's any other questions, I'll answer those. Let me see if I can take one more too. From Lydia, if I have a pending judgment and a trial date approaching, do I need to appear in court or make a response? The worst thing you can do is avoid court, avoid judges, because that is one way that you could actually end up in jail, not because of the debt, because you're in contempt of court for violating court orders. The only time that I see the sheriff go out for a civil debt is when you just completely ignore a judge, which you can imagine judges don't appreciate that. If you show some effort, if you show some remorse, if you can't make payment, that's one thing. But if you're not providing information and you're just ignoring the judge's orders altogether, that's when you really can get in some trouble. So make sure you don't do that. Just address it head on. I know it takes energy, and a lot of people are out of energy right now, but just make it happen. If there's anything I can do, then I'll make sure that I can help you out as well. I appreciate everybody joining us today. Again, if you ever need to get in contact with me, you can go to vanhornlawgroup.com. Give me a call at 954-637-0000. It's 4 zeros. And thanks again for joining me this episode of The Debt Life. I hope these topics are helpful and enrich your life. In about 2 weeks, we're going to do another one. So check back for the newest episode of Debt Life. Thanks, guys.